Good morning. The first case to come before the court is State versus Grad. And each of you will have 15 minutes to present your arguments to the court, and the appellant may reserve up to 5 minutes for rebuttal if you so choose. So we're ready to proceed.
Good morning, and may it please the court. Nikki Bazinski here on behalf of the appellant Kenneth Alex Grad, and I'd like to reserve 5 minutes for rebuttal.
That would be fine. Thank you.
Mr. Grad raises 4 assignments of error in this appeal. The first, that his trial attorneys rendered ineffective assistance of counsel for failing to present exculpatory medical testimony as part of his defense. Second, that with respect to count 6 and his conviction of that count, that was supported by insufficient evidence and the conviction was against the manifest weight of the evidence. 3, that the trial court committed an Apprendi violation here by relying upon a pre-sentence investigation report when it conducted its merger analysis. And finally, that the court's merger analysis was done in error. And I'd like to start with the last assignment of error and work backwards. But in order to understand where the court went wrong, it is necessary to go back to the beginning of this case and to examine how the state approached this particular case. We look at the indictment, and it seems that what the state did was divide up what it believed were abusive injuries into 2 time frames, one starting or occurring between May 26th and June 4th, and one occurring between June 6th and June 17th. It alleged that Mr. Grad committed injuries during those dates with various mental states. And that got them to 8 separate counts, including endangering children and felonious assault. Now, the jury found Mr. Grad guilty of each of those counts, but when we think about the conduct that the jury verdicts actually reflect, the only conduct that it reflects is that he committed or caused serious physical injuries, at least once during that first time period, and again during the second time period. But anything beyond that is purely speculation. The state in this case did not present any actual evidence of conduct. It was based upon injuries that were seen and alleged to have been occurred by Mr. Grad by Akron Children's Hospital. And so to use the state's general and ambiguous and speculative nature of this case with respect to the actual conduct to then support multiple convictions instead of merging them under RC 2941.25 as the legislature has intended is a merger error. Now, when we look to the third assignment of error that Mr. Grad has raised, we see how the court made this mistake. And it was because instead of relying upon the testimony that was presented at trial, the court went a step further. And it looked at testimony that was included in the pre-sentence investigation report. A Dr. Nelman, who never testified, who was never cross-examined, never put under oath, made statements in the PSI that he believed that the fractures to the hand had actually occurred several days before WG, the alleged victim in this case, was brought into the hospital. Well, if you believe that Mr. Nelman was accurate, and then you also believe that some of those fractures within that first time period were even older than that, then you can get to these 2 instances of conduct within that time frame. But the jury did not hear from Dr. Nelman. The jury didn't hear that testimony. And the only thing that the jury verdict reflects is that at some point during that first and second time period, Mr. Grad caused injuries. So the court here, we're alleging, committed an Apprendi violation because that reliance upon that PSI testimony allowed the court to impose additional sentences beyond the statutory maximum. The Ohio legislature has said if these are allied offenses of similar import, we merge them. We don't want to punish a defendant twice for the same conduct. But the court extended its statutory authority by using that evidence outside of the record that was never presented to the jury and could not have supported those jury findings.
Well, your opponent indicates that Apprendi really does not apply to this situation because we're not looking at enhancements. In other words, we're not looking at evidence that would have been introduced to enhance the penalty so that there would be a greater penalty than the statute just
statute, RC 2941.25 states that a defendant may be charged with allied offenses of similar import, but may not be convicted of them. So statutorily, the trial court is forbidden from imposing two sentences when those offenses are allied and of similar import.
But that's not the substantive statute for the offense. Do you understand what I'm saying? It's not like the felonious assault or the child endangering.
I understand, and this is unique, but it's because Ohio's allied offenses statute is unique. We are the only state in the entire country that does allied offenses or does merger with respect to the double jeopardy protection in this particular way. But Apprendi involved a state legislative scheme. And so in every case that falls under Apprendi, we're going to see these very unique and different ways that states have gone about increasing a trial court's authority to impose additional punishment. And that's what happened here. Mr. Grad received additional punishment, 8 additional years of punishment, because of a statement that was included in a PSI and never presented to the jury. Apprendi, the principle and the spirit of Apprendi, would not stand for that. It's a constitutional violation. And because it's a merger violation, the Supreme Court of Ohio has said this is plain error. So we would argue that those convictions need to be sent back to the trial court for a determination to see whether or not, absent Dr. Nelman's statement, these offenses should be merged.
Now, is this the assignment of error in which plain error was not argued in the merit brief, but after the state raised the issue, you raised it in the reply brief?
So merger is plain, well, the failure to merge allied offenses of similar import would be plain error. But the trial attorneys in this case did ask for merger and did provide a sentencing memorandum to that effect. With respect to the actual Apprendi violation, they did not mention that. However, again, with merger being a plain error, the Supreme Court identifying that over and over again, it's a sentence that's void under the law. A trial court cannot impose a statutorily unauthorized sentence. So when it does that, that is plain error.
Well, isn't that a little different though than, I understand what you're arguing, but isn't that a little different than whether or not you preserve the record by objecting to a PSI being used for purposes of merger?
There is a nuance there that I would concede does make this different from most of the Supreme Court sentencing or allied offenses case law. But again, with plain error, is there a constitutional violation? Is it plain and obvious? And in this case, we would argue the manifest injustice here is that Mr. Grad is being sentenced twice for the same offense or the same conduct. And this trial court has used a PSI, violated Apprendi in doing so in order to impose that double punishment. Now, with respect to count 6, which also factors into the merger analysis, our argument is that that count specifically is not supported by sufficient evidence. The only evidence regarding the skull fracture in this case is that it was accidental. Even the state's own experts testified that the skull fracture was accidental and could have been caused by accidental, or could have been caused accidentally. Dr. Steiner testified that the history provided by the Grad supported what he saw on the x-rays. And so to the extent that the jury found Mr. Grad guilty of felonious assault, which means he knowingly caused that injury, it simply isn't supported by the evidence that the state produced. And the state invited the jury to make that conclusion, or to draw that conclusion based on the other counts. But that isn't proof beyond a reasonable doubt of count 6. That's just using what they offered in support of their other counts to get that additional conviction. Even if one could argue that the testimony that was provided would allow, or would be sufficient, it's certainly against the manifest weight of the evidence. For the conviction to be beyond a reasonable doubt, and the only evidence that we have supporting it is a state's expert saying that it was accidental and that matches with the history, we don't have proof beyond a reasonable doubt on count 6 with respect to the skull fracture.
Remind me as to the timing of the expert's statement that the skull fracture was accidental. Was that before the other injuries had been discovered by x-ray and other means?
The state alleges that the skull fracture took place between June 1st and June 4th. And so the first time period begins May 26th and goes to June 4th. And then the second period is June 6th to June 17th. And there's actually a skull fracture identified in the bill of particulars there as well. So to the extent that this court doesn't agree and believes that there is sufficient evidence and that it's supported by, or it's not against the manifest weight of the evidence, that count then would seem to fall within merger, because the state's alleged that it is part of that count. I believe it's count 3 and 4 that occurred later. So all of these questions really get to the heart of what's difficult about this case, which is that the state's own experts state that this is an inexact science. We're working backwards. We're seeing things on an x-ray, and admittedly what we're seeing are these faint white lines. And from that, drawing the conclusion that Mr. Grad has done something at 2 different times that caused over 20 fractures to his son's body. We don't know what he did. We don't know how he did it. But we're alleging, because we see these faint white lines, that he must have done it in these 2 time periods.
Well, that evidence that you're speaking to can't be viewed in a vacuum. I mean, you have to consider some of the other evidence as to how he acted. There was one nurse, I think, who testified as to an encounter with him early in the child's life when she was about to change a bandage or to examine the child. Some of the discrepancies in what he said to the doctor about changing the doctor's appointments, all of those things are circumstantial evidence. Am I right?
It would certainly be circumstantial, Your Honor. And with respect to the first piece of testimony that you mentioned, that nurse, this case had been tried in several other courtrooms, in a juvenile case, in Laura Grad's case, and she was never called to testify, and she wasn't on the witness list. So it's curious that she's brought in later and is making this statement that after all these years she recalls Mr. Grad committing this act. With respect to everything else, I agree, we can't view it in a vacuum, but I think it actually speaks to how this case got to be where it is today, which is that none of this was being viewed in a vacuum by Akron Children's Hospital or the state. They saw x-rays and jumped to the conclusion of abuse immediately. And so everything that Mr. Grad said and did after that was viewed through this lens of suspicion. Whereas if we saw him in a different light, whereas if we were looking to see, are there other explanations? This is so odd, there's no bruising, no one's ever brought this up, no one's ever...
Counsel, I was just going to tell you, I was allowing you to answer Judge Moore's questions, but you are in rebuttal time if you'd like it.
Okay, thank you, Your Honor. So I think your question speaks to actually one of the problems in this case, which is that nothing was viewed in a vacuum. And as soon as that suspicion of abuse arose, everything Mr. Grad did and said previously and in the future was viewed under that suspicion. And so with respect to the changing of appointments, Laura Grad testifies. We had a well visit or a well baby visit at some point with a home nurse. She came, nothing was wrong, everything was going fine. So we didn't see the need, because it ended up happening later than usual, to go back to the doctors right away. We were going to wait for the 30-day visit. And they did take the child to the doctor when they noticed that there was an infection around the scrotal area in his mouth. And the doctor diagnosed that as impetigo and prescribed an antibiotic. But then, under this lens of suspicion and abuse, now it's become a scrotal injury, the result of slamming a child down or lacerating it. Everything changed once those x-rays came up. And rather than looking for the actual explanation, they targeted Mr. Grad as the only person who could have done it.
Well, your brief pretty much ignored the fact that these tests that you talk about were actually done, and to determine brittle bone syndrome and some of the other possibilities. And so that actually came in and was before the jury, correct? The testimony of Mrs. Grad.
They conducted some tests. They did not conduct every test. They did not provide WG or the blood that had already been drawn to the Grad family to conduct their own testing. No independent medical examination was ever done. Everything that was done to conclude that these other alternative diagnoses were not plausible was done by Akron Children's Hospital, who was testifying for the state. And they prevented Mr. Grad from accessing any evidence for which he could then seek his own alternative diagnoses. And I'll save the balance of my time for rebuttal.
Actually, you only have like 5 seconds.
Okay.
All right, thank you.
Good morning, Your Honors. I'm Scott Salisbury from the Medina County Prosecutor's Office. I am here because Matt Kern, who authored the brief, left our office in May, and Mr. Price, who is our new appellate person, is out on medical leave. So that's the reason, just so you know why I'm here. I was also trial counsel for this case. Your Honors, Mr. Grad received a fair trial. What wasn't addressed by counsel was the main portion of the appellant's brief, which was ineffective assistance of counsel. As this court is well aware, Strickland versus Washington was a death penalty case where the defendant pled guilty and counsel did nothing in between the time of the plea and the time of the sentencing for the mitigation phase. And that court found that that was trial strategy and that they upheld the death penalty in that case. And that's the standard which we go by. That it fell, did counsel fall beneath the objective reasonable standard of an attorney? And in this case, it's argued by appellant that just because he didn't call these expert witnesses that counsel was ineffective. And that's simply not the case, Your Honors. That was the reason that those witnesses weren't called, and they were here in the hallway. I spoke to them the day that Mr. Clammer was supposed to call them, and he told the jury. He did tell the jury he was going to call them. He did tell the court he was going to call them. He told me he was going to call them. He decided after he spoke with them that morning, after he spoke with them about the testimony that had come out in trial, not to call them. And
well, how much of what you just shared with us is, are we going to find in the transcript?
Well, I think it's in the transcript from Judge Collier putting it on the record that these witnesses were available, that Mr. Clammer did promise, to call them, and decided on a Monday morning, and as they were sitting out there, that, Your Honor, we rest.
I remember that part from the brief, but certainly not, what went into his deliberative process
Right.
after talking to them in the hallway. I definitely will see that.
Right. No, you will not, Judge. You definitely will not. However, that's the problem with trying to speculate as to why he didn't call them, and that's why, there's cases that say you cannot speculate, you can't get into why he didn't call them. It's trial strategy because of that very reason. I mean, he's not going to put on the record, Mr. Clammer's not going to come into court and say, well, Judge, I just spoke with my experts, and they're saying something different, so I'm not going to put them on. And of course, he's not going to do that. That would be ineffective assistance, I believe. He made a decision not to call these witnesses for whatever reason, but I don't think it's pure speculation to say that what happened was, because you can read their reports were all based upon this theory that Wesley had either vitamin D deficiency, which would lead to rickets, which he did not have at the time of trial. He was 6 years old. He did not ever have rickets, and Ehlers-Danlos syndrome, which is hypermobility. That's the double jointed process by which Aaron Stoltz took Wesley to Dr. Olenslager and had him tested, and he does not have it. He did not have it. He does not have it. His sister does not have it. When they refer in the brief, the appellant refers in the brief that Ms. Grad was diagnosed with Ehlers-Danlos syndrome, that is inaccurate. She was not diagnosed with it. She had suspicion of having that and was told to go get an additional DNA test and never did. And she testified, and I cross-examined her as to why she didn't go get that additional test to determine whether she actually had it, and she said she couldn't afford it. And that was her answer. She couldn't pay for it. So.
But was she later tested for that?
No.
She never was during the course of this?
She never was, and she testified to that. I asked her that. She had never, even to the day up until trial when she sat on the witness stand, and I think this court's aware, she was also charged and convicted of child endangering throughout this case. So she had every reason to have that test for her own defense, and she never got it. She simply never got the confirmation of that test, and her explanation as to why was she couldn't afford it. She didn't want to spend the money, even though, I hate to bring this up, but Mr. Grad went through, I think, 14 attorneys. They were all privately paid for, or nearly all. I shouldn't say all. A couple were court appointed throughout the whole process, and she testified that she had spent far more on attorneys than this test would have cost. So, I mean, it was her decision. She decided not to do that for whatever reason. So, counsel, as you go through that transcript, you can see that counsel was very engaged. Mr. Clymer was very engaged, had a lot of medical knowledge. The way he cross-examined the state's experts was extremely knowledgeable, extremely aggressive. He was challenging every single medical testimony that they had, even to the point of saying that these were not fractures. When you had 4, 5, 6 doctors, including radiologists, say these are fractures, these are bucket handle fractures, these are very distinctive for child abuse. He was questioning whether or not they even existed. My point being that he was not ineffective. He put up a very strong defense. He argued well. Like I said, cross-examined vehemently these doctors and challenged them at every turn. And to say that he was ineffective just for not calling witnesses, Your Honor, I guess if this court thought that and overturned the case and remanded it for a new trial, nobody can make defense counsel call witnesses. So the next trial counsel would simply retry the case and not call the witnesses, and then we'd stand back here again and say, well, they're ineffective, they didn't call these witnesses. And it would seem to go on forever, because no one can, this court, trial court, nobody can make defense counsel call witnesses. And so if this court finds that just because he didn't call his 2 expert witnesses for whatever reason, that's ineffective assistance, that would seem to be kind of a blueprint for the next attorney just to get a new trial, and we'd be retrying this case forever.
Well, you've argued that this point that's being raised by the appellant is more appropriately raised in post-conviction relief, so that an affidavit could be submitted so that we can get some sworn statement as to what was going on. For example, whether or not the appellant said, I want you to call these experts.
Right, and we do stand by that, and I think that there is a motion pending in the common police court for post-conviction relief. And they're holding that, I think, pending this court's ruling on these briefs. Your Honor, as far as the merger go, I think counsel misspoke or misstated when she said there was only 2 time periods that have been alleged in the indictment. There were actually 3 periods of time, and per her own brief, that she sets them out in a table for you. It's May 26th through June 4th, June 6th through June 17th, and June 1st through June 4th. So there are 3 separate periods of time. To say that all 3 counts of felonious assault would merge with each other, which seems to be the argument, although they argue counts 1 and 2 should be merged, when in fact they were sentenced concurrently anyway. So I'm not sure it's how that matters if they merge or not, because the sentences were run concurrent with counts 1 and 2. But as far as the 3 periods of time running consecutive to each other, I don't see how those could ever merge. Those are 3 distinct, very distinct periods of time, very distinct injuries in different stages of healing. It's been argued that count 6 related to the skull fracture. Well, that's not the only thing that the state alleged that period of time, June 1st through June 4th, occurred, the skull fracture. There was also, that's when the scrotal injury occurred, which Dr. Lee testified to in his opinion, that he believed, because there was also a laceration on the top of the penis and the bottom of the scrotum, that was a ligature, that he believes that could be a reasonable explanation for how that injury occurred. That happened in that time period. So I'm not sure, I guess I'm not sure where in the record that they're getting, the appellant is getting, that we only indicted him for the skull fracture of June 1st through June 4th. That was never our theory. We didn't argue that. There were other injuries that occurred during that time frame, and the jury found that. I think counsel is right that Dr. Steiner, and I think everyone agreed that the skull fracture was accidental if you believed, and we had no other reasonable explanation for it, if you believed Mr. Grad's explanation that he tripped and fell into a dresser, and that's how that injury occurred. So we never argued that was an intentional or a knowing felonious assault. We did not. There were other injuries. These are 26 fractures in various stages of healing, and to argue that all those occurred with one animus and one act is simply not the case, and that's not what the jury found. And what has been not mentioned, I don't want to say ignored, but not mentioned, is the obvious fracture of his leg, which started this whole case. Wesley's tibia, his left tibia, was broken in half. This was not a crack or a non-displaced fracture. This was like a pencil that broke in half, and it was grotesque. If you saw the x-rays, it was a bone that was broken in half. And no one has, appellant in their brief or either a trial, nobody had an explanation for that as far as brittle bone disease or vitamin D deficiency or hypermobility or anything else. That could only have happened in a 41-year-old day baby by blunt force trauma. And it was explained at trial would had to have happened like a fulcrum. In other words, a bending over an object or with two hands, literally snapping this child's leg. And that's the injury that brought, ultimately, although ignored for at least a week by both parents, and that's why Ms. Grad was convicted, ultimately brought to a podiatrist, and the podiatrist said, this is way out of my league. You've got to get this child immediately to a hospital. I cannot treat this child. Dr. Berkowitz testified he wouldn't even touch Wesley because he knew something was wrong. He made the Grads promise that they would take that child immediately. He wanted them to take him to Parma Hospital because it was right across the street, and they wouldn't do that. So he arranged for them to go to Akron Children's Hospital immediately that day, and he followed up and called not only Dr. Olenslager, but Akron Children's Hospital to make sure that child got there. That's how grave this was. There were strangers at playgroups telling Laura Grad that you have to get that child looked at. And her testimony was, he won't let me, meaning Alex won't let me. Do you think it's strange that the right side of his body's not moving? Yes, you should bring that up to the doctor. Alex Grad wouldn't let her bring that up to the doctor. Don't worry about it, he's fine. That's the type of testimony we had in this case. And that's why endangering children and felonious assault are separate acts. Not only did he inflict these injuries, and again, as this court has mentioned, through circumstantial evidence, of course we didn't have eyewitnesses. You never do in these cases, but you have to show them by circumstantial evidence. He was the only caregiver. He was with the child. He admitted that. And Laura Grad herself testified, if the doctors rule out any medical reason for this many fractures, my husband must have done it. That was her testimony. And when we showed that, we believe clearly, and the jury came back with the verdicts, or we believe appropriate verdicts. We don't think these counts merge. We don't think Apprendi applies. Apprendi, I think as counsel alluded to, or Your Honor alluded to with counsel, was an enhancement. That was a statute in New Jersey where someone shot into a building, and it was a hate crime statute that had to be alleged that was a hate crime. He was only charged with shooting into a building, an apartment complex of African Americans, and they did not allege that it was a hate crime in the indictment. When they sentenced him, the court found that it was a hate crime, but it wasn't alleged in the indictment, and that's where Apprendi comes from and says, no, you have to allege that in the indictment, and that has to be proven. You can't do that after the plea. That's simply not the case here. There are no enhancements here. Appellant's trying to argue that consecutive sentences are enhancements. They're not. I mean, yes, are they punished more severely for consecutive sentences? Yes, but that's because they committed several crimes. That's not an enhancement statute, and that's what the state believes is what Apprendi stands for.
And counsel, you're out of time.
Thank you, Your Honor.
Thank you.
Appreciate your time.
No problem. Actually, I would like to run over about 15 seconds because I'm going to let her have about 20 seconds to address the board.
Thank you, Your Honor. I just wanted to touch on one thing that stood out to me with respect to the time periods, because I know that issue could be confusing. So the third time period the appellee is referring to, the June 1st through June 4th, is contained within that first time period. So there are just two sets of time, and because there's no actual evidence of how this occurred, again, we're looking at caused serious injury. That's the conduct. And that happened in the first time frame, and it happened in the second time frame, is what the jury verdicts reflect. With respect to count 6,
Counsel, I'm sorry, I can't let you.
Oh, I'm sorry.
It's been over 20 seconds. Thank you so much. I appreciate it. Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides. And we also release it on our website and on the